Bienvenidas, bienvenidos a este cuarto encuentro de Diálogos de Derecho Internacional de la Escuela de Derecho de la Universidad de Itela. Soy Alejandro Chetman, profesor de Derecho Internacional y director de la carrera de Abogacía. I will now turn to English to welcome our very special guest tonight, Professor Dapo Akande. We are delighted to have you tonight in London. Here it's early afternoon still, but we are delighted to have you and hope to welcome you in person in the not so distant future once this crazy pandemic has receded. I'm sure you will all agree that Dapo needs no introduction to an international law audience and probably beyond that. He's by any plausible measure one of the most prominent and interesting international law scholars in the world today. I will keep this introduction short so we can listen to him. He is Professor of Public International Law at the University of Oxford, where he co-directs the Oxford Institute for Ethics, Law and Armed Conflict, the ELAC, and the Oxford Martin Program on Human Rights for Future Generation. He has published extensively in many areas of international law. He's one of the authors of the authoritative Oppenheim's International Law, the United Nations, and he's also a member of the group of experts who prepared the Tallinn Manual 2.0 on the international law applicable to cyber operations. He has been most recently nominated by the United Kingdom to the United Nations International Law Commission, and he will talk today on the diversity of rules on the use of force implications for the evolution of the law. Dapo will talk for about 25 to 30 minutes, and then we will have quite a bit of time for questions and answers. Please, everyone, list your questions using the Zoom, the chat function in Zoom. Welcome, Dapo. It's really a pleasure to have you. We're honored to have you. The floor is yours.
Thank you so much, Alejandro. Thank you for that very kind introduction. It's a pleasure to be giving this talk, and I hope one day that I will actually get to come to Argentina. I have never been, and I look forward to that. I'm also looking forward to interacting with those of you who are watching and or listening during the Q&A part of this session. Just a couple of weeks ago, the world marked the 70th anniversary of the entry into force of the Charter of the United Nations. And in my talk today, what I want to do is to address the question whether the law relating to the use of force, as it's set out in the UN Charter, is capable of adapting to meet new threats and new challenges facing the international community. My focus is not on the substance of the rules, but rather on how the rules change. And in particular, what I wish to do is to show that we need to be attentive to the diverse nature of the rules in this area when we think about the possibility of their evolution. Now, it was around the time of the 50th anniversary of the UN 25 years ago that literature began to emerge, suggesting that we might think of the UN Charter as a constitution for international society. Whether one agrees with that characterization or not of the Charter shares at least a couple of features with constitutions. So first of all, it aims to lay down an overarching framework for the community it applies to. And secondly, it is intended to be an abiding document in terms of duration. And these features immediately raise questions about whether the document can continue to regulate new and unforeseen challenges. And this is particularly true of the Charter rules relating to the use of force. One can think of at least 4 areas where it has been argued that the rules in the UN Charter ought to be adapted to meet new changes, or where it has been argued that they have in fact been adapted to meet those challenges since the entry into force of the Charter 75 years ago. So those 4 areas are, first of all, the debates around the permissibility of the use of force by states, acting individually or collectively, but without UN Security Council authorization for the purpose of stopping or preventing a humanitarian catastrophe. So these are the debates about whether there is a rule permitting humanitarian intervention. As we know, the UN Charter does not include in its text such a rule, but a few states, including the United Kingdom, now maintain, or maybe I should say especially the United Kingdom, now maintains that such a rule exists, and scholars continue to debate whether such a rule should exist. So number one, humanitarian intervention. Second area where it's been argued that the rules either have been adapted or may be adapted. So second, it may be argued, in fact, it has been argued, that the rules relating to the use of force by the UN Security Council, acting under Chapter 7, have changed in the time between the adoption of the Charter and now. So the Council is now seen to possess the competence to act both with regard to internal situations and also competence to prevent or put an end to humanitarian crises. Arguably, the drafters of the Charter did not foresee these roles for the Council, and they had their minds mainly on Council action in interstate conflicts. Third, there have been arguments about the legality of the use of force by states in anticipation of armed attacks. So this is the debate about anticipatory or preemptive self-defense. While Article 51 of the Charter provides that nothing shall impair the inherent right of individual or collective self-defense if an armed attack occurs, quote unquote, some have argued that the victim state does not need to have suffered the armed attack before the right to self-defense can be exercised. Fourth, there is the debate about whether the right of self-defense can be exercised in response to armed attacks by non-state actors. There's nothing in the text of Article 51 of the UN Charter that expressly specifies that the right of self-defense only exists in relation to an armed attack that comes from a state. But in 1986, the International Court of Justice held in the Nicaragua case that the right of self-defense exists in response, that the right of self-defense exists in response to armed attacks that are attributable to another state. So on this view, self-defense can only be exercised with respect to an armed attack originating from a non-state actor, where the non-state actor was sent by a state, or a state had substantial involvement in the acts of that non-state actor. Now, this view of the ICJ in 1986 seems to have reflected the state practice of the time, especially as was set out in the UN General Assembly's 1974 resolution on the definition of aggression. That resolution was adopted by consensus. However, since September 11th, 2001, a number of states have taken the view that self-defense can be exercised in response to attacks by non-state actors, even when the attack by the non-state actor is not attributable to a state. And of course, it was on this basis that the US and other states took action in Afghanistan against Al-Qaeda and the Taliban in 2001. It was also on this basis that a coalition of states took action in Syria against ISIS more recently. And there are many other examples that we can give, actually from across the globe, whether it's Turkey against the Kurds in Syria or in northern Iraq, whether it's Uganda or Rwanda going into the Democratic Republic of Congo, in your continent, whether it's Colombia taking action against FARC bases in Ecuador. We can see these claims about self-defense against non-state actors being made by states, even in cases where they do not allege attribution. So let's turn to the evolution of charter rules through state practice, and let's look at the structural issues. So in each of these four areas that I have just outlined, it may be argued that the rules as envisaged in 1945, or as articulated at some later point since then, have required adaptation to new challenges. The arguments as to whether these rules have evolved almost always go straight to analyzing whether state practice today or over time is such that we should consider that a new rule has emerged. Or sometimes these arguments are more evaluative. They consider whether the rules should change to reflect a perceived need or to cure a perceived deficiency. Less attention is usually paid to the question of how can these rules change? But this question is important. Indeed, I would say critical, because the rules relating to the use of force are embedded in a treaty instrument with a difficult amendment procedure. Article 108 of the UN Charter provides that amendments will come into force after a vote adopted by a 2/3 majority in the General Assembly and after ratification by 2/3 of the membership, including by all the permanent members of the Security Council. Now, in the Nicaragua case, the International Court of Justice held that the prohibition on the use of force in Article 2(4) of the Charter and the right of self-defense in Article 51 are also to be found in customary international law. And this might lead one to think that because these are rules of customary international law, that they will change and they will adapt in the usual way that customary international law evolves over time and in accordance with evolving state practice. And indeed, if you look at the debates about the 4 issues that I mentioned earlier, it is typical to see extensive reference to state practice over time with the implicit suggestion, and many times it's just implicit, that as practice evolves, so will the rules. That's the kind of assumption that, we look at state practice and whatever state practice is telling us, that's what the rules are. However, when one stands back to think about the structure and the position of the rules in question, to think about the diverse nature of those rules, it becomes clear, I think, that the issue of how they may or how they have changed is actually not that simple. Even if the rules relating to the use of force by states are contained in customary international law, they remain nonetheless treaty rules. Moreover, they are not just rules in any old treaty. They are rules in the UN Charter which claim superiority over other treaties. So what are the structural problems with simply analyzing changes by reference to evolving state practice? It should be acknowledged that state practice may be used in 2 different ways in order to support an argument that the rules have evolved. So first of all, practice may be used to underpin an argument that customary international law has changed. And here, of course, we need a general state practice plus opinio juris. Secondly, and differently, practice may be used in the interpretation of treaty rules where it establishes the agreement of the parties as to the interpretation of the treaty. So this is Article 31(3)(b) of the Vienna Convention on the Law of Treaties. Now, 3 out of the 4 areas that I highlighted earlier deal with the law relating to the use of force by states, as opposed to the 4th, which deals with the law relating to the use of force by the Security Council. Now, in those 3 areas, it is impossible, I think, to say that the practice establishes the agreement of the parties as to the interpretation of the treaty. One need only to think about the debates about anticipatory self-defense or self-defense in response to attacks by non-state actors. So usually, the claim is that the practice has established a new customary rule, or that the practice has changed or led to a change in customary law. But this leads to the question about the relationship between customary changes and the UN Charter. Now, there are 3 obstacles to accepting that customary law changes can affect the law on the use of force in the Charter. So 3 arguments against what I think is the commonly assumed notion that just that as custom changes, then the rules relating to the use of force will change. So first of all, though it is conceivable that a customary rule can take precedence over a treaty, the ordinary presumption is that treaty rules will prevail over custom, unless there is an indication that the parties to the treaty intend to abandon the treaty provision. So this means that the treaty or the treaty provision has fallen into desuetude. Okay? So ordinarily, treaty rules prevail over custom unless they're falling into desuetude. The second obstacle to the argument that custom can change the rules relating to the use of force in the UN Charter, the second obstacle derives from Article 103 of the UN Charter, so the special position of the Charter. Of course, as you know, under Article 103 of the Charter, obligations under the Charter prevail over obligations under any other treaty. Now, to be clear, this is not a rule that relates directly to the relationship between the Charter and customary international law. Instead, what it does is that it indicates that parties may not enter into a treaty which would derogate from or amend their Charter obligations, except by way of amendment to the Charter itself. But if the parties to the Charter cannot change their Charter obligations expressly by treaty, it would be odd if they can amend their Charter obligations implicitly by custom. If they can't get together, write out explicitly rules in a treaty and say, this will prevail or change our Charter obligations, ratify it, and that would be effective. If they can't do that, it seems strange to argue that implicitly, just by custom, they can do it. The third obstacle to the argument that custom can change the rules relating to the use of force in the Charter, the third obstacle is that the prohibition of the use of force, or to be more accurate, aspects of that prohibition are considered to be rules of jus cogens, peremptory norms of international law from which no derogation is permitted. And one consequence of the fact that some aspects of the prohibition are jus cogens is that it can only be changed, the prohibition, or at least those aspects can only be changed by another peremptory norm of international law. So this is Article 53 of the Vienna Convention on the Law of Treaties. So to summarize what I've said so far, the bar seems to be set high, indeed very high, for adaptation of the rules relating to the use of force. And there are good reasons for this. These rules reflect some of the fundamental features of the post-World War II legal system. Indeed, the prohibition of the use of force is central. It's a central aspect of that legal system adopted in 1945. But despite all that I've just said, adaptation is possible and has been possible to meet new challenges. But how? That's the puzzle, how? So I would say, first of all, that there are indeed occasions when subsequent practice can legitimately be used to interpret the Charter under Article 31 of the Vienna Convention on the Law of Treaties. So the second use of practice that I talked about earlier. So now this is practice being used to interpret the treaty as opposed to practice being used to form new custom. And this is particularly the case with regard to the UN Collective Security Scheme under Chapter 7. So there we have seen the practice of the Council, which has been endorsed implicitly or even explicitly by the membership of the UN as a whole, which has interpreted the Charter in new ways. So one can think of the interpretation of the concept of threats to the peace to include internal matters or to include humanitarian challenges. This has opened the door to the Council authorizing force on numerous occasions now for the purpose of protecting civilians or in internal situations. And that practice was explicitly endorsed by the membership of the UN by consensus in the provisions of the World Summit Outcome Document of 2005. So this is the famous document that establishes the responsibility to protect doctrine. And that General Assembly resolution, which was adopted incidentally by heads of states and government, so at that level, adopted by them by consensus, expressed support for actions by the Security Council under Chapter 7 to help protect populations from international crimes. And whatever the correct interpretation of Article 39 of Chapter 7 might have been in 1945, there is now subsequent practice establishing the agreement of the parties to the Charter, which must be taken into account under the Vienna Convention on the Law of Treaties in interpreting the Charter today. So that's one way in which adaptation can take place. Secondly, despite the points that I've made earlier, changes to customary international law are not irrelevant to the law on the use of force. From what I have said earlier, I think one can see that it is difficult, actually, to see how changes to customary international law can affect the prohibition of the use of force in Article 2.4. That is, it is difficult to see how custom can create new exceptions to that prohibition for the reasons I gave earlier. However, changes to customary law are relevant to the evolution of the right of self-defense under Article 51 of the Charter. The text of Article 51 refers to the inherent right of individual or collective self-defense. And in the Nicaragua case, the ICJ accepted that this is a reference to the customary international law right. Now, this is not a static reference to custom, by which I mean this is not simply a reference to custom as it was in 1945. Rather, it's a dynamic reference to custom. In other words, it's a reference to the customary law of self-defense as it evolves over time. So what Article 51 is saying, this is what I'm suggesting, that what Article 51 is saying, in short, is that despite the prohibition of the use of force, states may act in accordance with the customary right of self-defense, while of course it adds some procedural obligations that must be fulfilled. So customary self-defense is preserved by the Charter, and that is why we have regard to the requirements of necessity and proportionality, though these are not to be found in the Charter. So what this means is that as the customary law of self-defense changes, the Charter accommodates those changes, since the Charter rule on self-defense is only given content by the customary law on self-defense. And it is this dynamic reference to custom that allows the law of self-defense to adapt and makes it legitimate for us to debate the implications of practice, for example, around self-defense against non-state actors. So if customary international law allows such uses of force, then so does Article 51. However, I think we must be careful in taking this methodology of assessing custom we must be careful of taking this methodology of assessing custom outside the law of self-defense to other areas of the law relating to the use of force, particularly when one is thinking of somehow adapting the prohibition of the use of force in 2.4 or adapting the UN Collective Security Scheme. In these areas, one would need a different methodology, a different concept of adaptation. Not customary evolution, but practice that establishes the agreement of the parties as to the interpretation of the Charter. Now, why does this methodology not apply to the prohibition of the use of force? Though the ICJ pointed to the identity of custom and Charter rules on force, both in relation to the prohibition in 2.4 and self-defense in 51, though the court said, look, there's this identity of custom and Charter, it's important to realize that the relationship between custom and the treaty, i.e. the Charter, is not the same in both of those cases. As just shown, in the case of Article 51, the identity of custom and treaty arises because the treaty rules preserve customary rules of self-defense. It's the reference in the treaty to custom that maintains that identity. In the case of the prohibition on the use of force, though, the identity of the rules arises not because the treaty itself says anything about custom, but because custom has now come to mirror the treaty. There is no intrinsic link between the two. A change in the customary rule would not in and of itself change the treaty prohibition. That prohibition would remain unchanged unless it were to be interpreted differently using the rules of treaty interpretation. And the main significance of the point that any changes to the customary prohibition of the use of force does not change the treaty prohibition is to be seen with regard to arguments around humanitarian intervention. Any rule permitting humanitarian intervention would have to create a new exception to the prohibition of the use of force. Recall that this prohibition has three dimensions. It exists as a customary rule. Number two, it exists as a treaty rule in Article 2.4. And number three, it, or at least a part of it, the prohibition of aggression, is a peremptory norm of international law. It's a norm of jus cogens. Now, there's much debate as to the implications of practice regarding the use of force for humanitarian ends for the doctrine of humanitarian intervention. So a lot of debate about, is there enough practice? Is there not enough practice? Some governments, most notably my own, the UK government, argues that there is a rule permitting such intervention. Others have argued more recently that the silence, the failure to condemn by many states actions, for example, taken by the US, the UK, France in Syria in response to the use of chemical weapons, that it means that even if the law hasn't changed, well, it's changing, they will say, or at least it's not as clear as it once was. However, all of this assumes that the creation of an exception to the customary rule can change the treaty prohibition. But even if there was much more practice than we see now, this would not affect the treaty prohibition to be found in Article 2, paragraph 4. And the argument that the creation of a customary law exception to this prohibition in the Charter, the argument that we can have customary law create a new exception, I think would have dramatic implications for the primacy of the UN Charter. So there are actually structural issues that we need to be very sensitive to when we make this argument. The argument would upend Article 103 of the Charter, essentially making it not very meaningful anymore. In the context of the imposition of sanctions, for example, by the Security Council, there have been states that have refused to comply with sanctions for one reason or another. For example, if we think sort of 25, 26 years ago, a bit more than that, when the Security Council imposed sanctions on Libya, the Organization of Islamic Conference urged its member states not to comply with those sanctions. Now, one might ask whether it is possible to develop a customary international law exception to the obligation imposed on states under the Charter to comply with the sanctions that are imposed by the Security Council. I would imagine that some of the states that now argue that custom can change the prohibition on the use of force would take the view that such a customary rule relating to sanctions could not change the obligation of states to abide by the sanctions imposed by the Security Council. We would also need to think about the implications of the prohibition of aggression being jus cogens. No rule of custom can come into existence if it comes into conflict with a peremptory norm of international law. So we see this in the International Law Commission's draft conclusions on peremptory norms of general international law. Draft conclusion 14 stresses this point, that no rule of custom can come into existence in the first place if it comes into conflict with a peremptory norm. Now, given that a rule permitting humanitarian intervention would not only modify the prohibition of aggression, but it would also, I would argue, be in conflict with it, in that it would seem to permit things that the prohibition of aggression would otherwise prohibit, it is difficult to see how a rule of customary international law permitting humanitarian intervention could even come into existence in the first place. Norms of jus cogens can only be changed by other norms of jus cogens. Thus, for there to be a customary rule permitting humanitarian intervention, it would seem that it can only come about by a rule of jus cogens. Okay, so I'm getting towards the end. Let me talk about whether there are any possibilities for the emergence of a rule permitting force for humanitarian purposes. Now, what I have said so far does not mean, at least in my view, does not mean that it is impossible for the law to be developed to permit states to use force for humanitarian purposes without Security Council authorization. So I can see three possible ways in which the law can develop to allow for use of force for humanitarian purposes, even without Security Council authorization. The first way would be to argue that there is a jus cogens rule, so the point I've just been making, that there is a jus cogens rule that permits humanitarian intervention which modifies the jus cogens prohibition of force or prohibition of aggression. And for this to happen, one would have to give thought to the possibility that we can have jus cogens rules that contain permissions rather than jus cogens rules that contain prohibitions. The second way in which there might be evolution of new rules relating to the use of force for humanitarian purposes would be to argue that Article 2.4 is to be interpreted as not prohibiting the use of force for humanitarian purposes. Now, for all sorts of reasons, which I won't go into now, this would not be the interpretation of that provision that I think would be arrived at if you use the ordinary rules of interpretation contained in Article 31 of the Vienna Convention. In other words, I think that the correct interpretation is that Article 2.4 actually does prohibit the use of force for humanitarian purposes. However, if there were to be subsequent practice which establishes the agreement of the parties as to the interpretation of this provision, then matters may change. They can change. Now, the third way of breaking the stranglehold of the UN Security Council on the use of force for humanitarian purposes is for that force to be authorized by the UN General Assembly under the Uniting for Peace Resolution of 1950. Now, that resolution provides, as you may know, that if because of a lack of unanimity amongst the permanent members of the Security Council, if for that reason the Security Council can exercise its responsibilities to maintain international peace and security, then the General Assembly shall consider the matter immediately with a view to making appropriate recommendations to members for collective measures, including, it says, so those recommendations may include, in the case of a breach of peace or act of aggression, they may include the use of armed force when necessary to maintain or restore international peace and security. So this 1950 General Assembly resolution foresees the possibility that the UN General Assembly might actually take collective measures, including the use of armed force, to maintain international peace and security. Now, whether the General Assembly does indeed have this power is ultimately to be traced back to the UN Charter rather than to this resolution. And Article 11, paragraph 2 of the Charter provides that the General Assembly may discuss any questions within the scope of the Charter, may discuss questions relating to the maintenance of international peace and security. The General Assembly may make recommendations on these issues. That provision, Article 11 of the Charter, also says that its provisions are subject to Article 12, which provides that the Assembly may not make recommendations while the Security Council is exercising its functions in relation to a dispute or a situation. However, more recent UN practice, the legality and the effect of which have been confirmed by the ICJ, both in the Kosovo advisory opinion and the Israeli Wall in Palestine advisory opinion, more recent practice suggests that matters may be dealt with in parallel by the Security Council and the General Assembly, and that the Assembly may make recommendations even when these matters are being dealt with in parallel. So then the only question will be whether that's left is whether an Assembly resolution recommending force would be deemed not a breach of the prohibition of force under Article 2.4, in the same way as when a Security Council resolution authorizes force, that's not deemed to be a breach of Article 2.4. And this is an interpretation of the Charter that's open to UN member states to take. If there were agreement on that principle, the agreement would be an important point to be taken into account in the interpretation of the Charter. And this way this way of achieving the goal of liberating humanitarian uses of force from the Security Council, this argument would not fall foul of the various structural problems that I have alluded to above. And it would avoid the suggestion that simply because there's a change of customary international law, that this then means that the UN Charter has changed, or it means that a rule of jus cogens has changed. So there you have it. Those are my arguments relating to whether or not the Charter provisions relating to the use of force can change. And I look forward to whatever questions or comments you may have in the session that we now move into.
Thank you so much, Dapo. That was really, really, really interesting and such so clear as your writing characteristically is. We have several questions already to all participants. If you want to make a question, you can write it down on the chat function of Zoom. So the first question is, you mentioned that custom plays a particularly important role in the use of force in self-defense compared to other areas of the use of force. Do you think that custom on self-defense can go beyond the explicit terms of Article 51, or is it constrained by the text of Article 51?
So that's a good question. My answer is that it can go beyond the text of Article 51. And for example, take the criteria for a lawful use of force in self-defense. It's universally accepted that those criteria include the criteria of necessity and proportionality, which are not to be found in the text of Article 51. Those are criteria that come from customary international law. And this is part of my argument that all that Article 51 is doing is that it is just making a reference to customary international law. And that's why those criteria of necessity and proportionality are important. So yes, it can go beyond.
Can I go back on this a little more? So do you think that states could do away, for instance, with the requirement of an armed attack and say, oh, we don't need an armed attack anymore. We need a different standard. And that would be, again, compatible with your reading of how the charter is structured.
So this is a good question. And of course, it goes to one of the four things that I mentioned, the kind of preventive, anticipatory, preemptive self-defense debate. So because Article 51 in its text actually requires an armed attack, I don't think that states can do away totally with the notion of an armed attack, because Article 51 conditions the customary right of self-defense on the occurrence of an armed attack. Now, of course, the whole question of what is an armed attack requires interpretation. And when has an armed attack occurred? You know, when does it start? When does it end? All of that requires interpretation too.
Excellent. Thank you so much. Relatedly, some of the practical implications of this claim, which I find really interesting. So do you think that the ICJ should approach differently the law on self-defense in terms of its methodology from other questions on the use of force, and should the UN Security Council have a different approach given the different role that custom and treaty plays in each realm?
So I don't think that the ICJ should adopt a different methodology from the one that it has already adopted, because the court has not so far been faced squarely with the question of whether or not Article 2.4 can change. It has been faced with whether or not Article 51 can change. So it has been faced with that in the context of self-defense in response to attacks by non-state actors. And I do not fault the methodology of the ICJ on the Article 51 question and on whether or not it has evolved, because it's in keeping with the point I have just made that, you know, you can look at practice and you can look to see whether practice has evolved. I question their actual conclusion and whether they are right about the answer that they give, particularly in the Israeli war in Palestine case and in the armed activities case. But, you know, the talk wasn't so much about the substance, it's about the methodology. I think the methodology is right in relation to 51, but the answers they've given, I think, are problematic. In relation to the Security Council, again, I don't think they should change their methodology, because what I'm saying derives in part from how the ICJ has approached the evolution of the rules relating to the Security Council. So I didn't mention the Namibia advisory opinion, but this was, of course, the advisory opinion where the ICJ said, look, abstentions to Security Council resolutions are not a veto by permanent members. And there, the methodology was about how this is the practice of the not just of the Security Council, actually the practice of the UN as a whole accepts this. So in that sense, it fits in with the point that I made about the evolution of Security Council uses of force.
Thank you. That's really illuminating. So more or less on a related topic still. So given what you just, or what you said in your talk about the status or the role of the UN Charter and the relevance of Jus Cogens norms in this area, which do you think is the best institutional setting to discuss or argue on changes in these areas of the law? Is it the General Assembly, the International Law Commission, the International Court of Justice, the Security Council, or is it best to leave it to states to discuss it informally and in a decentralized fashion?
So I think I think a decentralized fashion is inevitable, and one which includes all of the actors that you have been talking about. So what I mean by that is that because evolution can occur through practice, whether that is practice that establishes the agreement of the parties for the purposes of treaty interpretation, or practice that is going towards customary international law, but because practice can change the rules in the way that I identified, then what states do is going to be important. But of course, what states do includes also what they say. So the claims that they make in discussions in the Security Council, the claims that they make in the context of the General Assembly, these will be important indicators to us of where the practice is going. And this is actually, and I don't think we can avoid this, because one, this is what both custom and treaty interpretation requires. But two, actually, in this particular area, one of the things that's really important to remember is Article 51 on self-defense requires states, when they act in self-defense, to report it to the Security Council. So that's a procedural requirement, but it actually has this interesting implication that it kind of forces or pushes states to say something about their use of force, right? They have to explain what they're doing and provide a justification. And so inevitably, this will be practice that will then be used to make all these arguments. And of course, the ICJ will continue to be important, because if cases arise, which they do from time to time, then what it says, particularly on what the customary law rule is, what it says will be important.
Thank you. I have a broader question now, a more general question about international law, and it's how is it possible to invoke the Vienna Convention to allow state practice to be used for interpreting the UN Charter as regards nations that have not ratified the Vienna Convention?
It's a good question. So the kind of working assumption that I had in the paper, but I think this is confirmed by case law as well, the assumption is that these rules in the Vienna Convention are rules of customary international law. So it's generally agreed that most of the rules in the Vienna Convention are rules of custom. In fact, to add to the good question, it's not just the fact that states may not have ratified the Vienna Convention, which means that the Vienna Convention as a treaty doesn't apply to that state. But it's also the fact that the Vienna Convention, on its own terms, only applies to treaties that come into force after the entry into force of the Vienna Convention. Now, of course, the UN Charter came into force many years before the entry into force of the Vienna Convention. But nonetheless, as I say, I'm applying those rules in the Vienna Convention as custom. And in fact, the ICJ said this, the rules in Article 31 are to be regarded as rules of customary international law.
Thank you. One of the members of the attendees of the talk says that he is very convinced by arguments and has two questions. The first is whether you can identify in states legal justifications for the use of force, something resembling your persuasive reading on the possibility of adaptation in the rules on the use of force, or have they rather been rather negligent in their actions and justifications? And second, and relatedly, Could state practice and opinion juris in this area of the jus ad bellum say if there was an extended consensus in favor of humanitarian interventions outside the scope of your arguments? Could that ever trigger changes in the secondary rules of international law? So could change in the primary rules push or trigger changes in the secondary rules of international law?
So the first question, can I identify in the practice of states legal justification that resembles my reading? So I would say yes. So yes, in the sense that, look, what am I saying? I'm saying self-defense can evolve in accordance with custom, and states make these claims, right? They make the claims that the rules relating to self-defense have changed in this area or in that area. For example, I think in the case of self-defense in response to attacks by non-state nationals. Now, we can disagree on what the right position is, but certainly states make this argument. The court, the ICJ, on the other hand, has not accepted it. But nor has it dismissed that it can evolve. It's just saying it hasn't changed. The law hasn't changed. Okay. And then in relation to the other side of the coin, where I'm arguing that the rules relating to humanitarian intervention cannot just come about by customary international law. Okay, so most states in the world have rejected, they've rejected arguments that international law allows for humanitarian intervention. So we saw this around the time of the Kosovo incident, the declaration of the South Summit, the G77 adopting decisions saying, we don't accept that the law has changed. But what's not clear is whether or not they accept that the law can change, right? Because that's really my own point, that actually can't actually even change by custom. I don't know if states have actually given enough thought to that particular issue. So your second question was about whether or not the practice and the opinion juris can result in changes in the secondary rules of international law. So I make 2 points. Point number one, in terms of the secondary rules, remember that self-defense is also actually a secondary rule, right? So it's also a circumstance precluding wrongfulness. Not so much precluding the wrongfulness of a use of force, but actually precluding the wrongfulness of other violations of international law. So if a state were to, engage in a use of force and it was sued, for example, for destroying property, and they say you have to make compensation for destroying property, they might say we acted in self-defense, and they're using the rules of self-defense as a circumstance precluding wrongfulness vis-a-vis a rule that would have otherwise prohibited that action. So yes, it can change self-defense. More difficult is, can it change, for example, the rules relating to necessity? Okay, so can we have, say, something like humanitarian intervention, for example, evolve not as an exception to the prohibition on the use of force, but rather as an application of necessity? That's tricky, that's a tricky one, because generally speaking, we haven't taken the view that these circumstances precluding wrongfulness can be used to justify or to excuse, the use of force. So it would be tricky there because you'd be applying it to the use of force. Tricky also because of the interaction with norms of jus cogens, right? So you can't plead a circumstance precluding wrongfulness as a reason for violating a jus cogens obligation. So that's another difficult point there.
Thank you. I have two connected questions again. You have spoken about the adaptation of the UN Charter's provision related to the use of force. However, there's a difference between arguing for a new interpretation of the Charter or arguing that the Charter has been modified, albeit informally. So two paths which are admittedly sometimes difficult to distinguish. Do you think that these two different roads to change can be perceived differently by the international community? So it might be better to go for one over the other? And the second question is, aside from the many problems that you mentioned, what do you think about the methodological difficulties of gathering state practice identified by scholars such as Chimney, difficulties such as bias that there is towards the practice of countries that have the resources to publicize their practice, as well as the predominance of the practice of the English-speaking countries?
So to take the first question about which of the routes is easier to take, so to say it's a new interpretation or to say that the rules have been modified. So my view is that the easier one actually is, at least technically, the easier one is to say that the rules have been modified. That might sound strange actually, but insofar as we're talking about changes to customary international law, under Article 51, it's easier to modify it. Why is it easier? It's easier because a change to customary international law only needs general state practice and opinio juris. That's the threshold, general state practice. Whereas to say that, we have a new sort of interpretation of the Charter requires, under the Vienna Convention, it requires practice which establishes the agreement of the parties as to the interpretation of the treaty. So now, that doesn't mean that every single state must have engaged in that practice. But what it does mean is that if even a few states object to that practice, then you cannot say that this is practice that establishes the agreement of the parties. Whereas with custom, it's possible that if a few states object to it, you can still say that custom has changed. You might have difficulty there arguing about what do we do with the persistent objector rule, and does it apply to norms of use cogent? You might have those questions. But at least in principle, custom can change without there needing to be actually widespread agreement among states. So that's what I would say about that one. Now, the other question, I have now forgotten what the other question was, the related one.
It's about the methodology, the methodological difficulties to gather state practice and the bias and
Yeah. So excellent point. I think it's undeniable that this is true. Having said that, though, I think it's now 50 years ago, more than 50 years ago, more than actually, close to 60 years ago, that Rosalind Higgins published her book on the development of international law by the political organs of the United Nations. And actually, this goes back to the question that was put to me earlier as to what's the best place, what's the best forum. See, one of the interesting things about the UN as an institution, both the Security Council and the General Assembly, is that it actually provides an opportunity for states to express themselves as to rules of international law, and to do it in a way which is at least relatively not very costly. There are still obstacles and things like that, but it provides a kind of a forum, a focus for us to see what practice is, as long as you accept that practice includes what states say in addition to what they do. So this sort of just narrows the gap between countries, and it makes it easier for us to find out what states are actually thinking and saying, maybe even doing on particular issues.
Excellent. We have 4 more minutes, and I will squeeze the last 2 questions. The last one, it's a bit broad, but you'll see what you want to do with it. So states have ceded the use of force in a system of quasi-subordination in the Security Council through Article 2.4 of the UN Charter. Do you believe that the application of Chapter 7 of the Charter as an exception to the prohibition to the use of force would violate the principle of non-intervention in the internal affairs of the states, in addition to implicitly repealing a rule of jus cogens? That's the first question. And the last question, which is broad, is, and it's by one of our students, is, do you think that humanitarian intervention in Venezuela would be lawful?
So the first, just remind me very quickly, the first one.
The first one, I think, refers to action by the Security Council authorizing use of force on humanitarian grounds, whether it would violate the principle of non-intervention, while at the same time repeal or implicitly modify a rule of jus cogens.
Yeah, so a good question. You know, it's just funny, actually. Just this morning, I was reading, you know, some of you may know that I am one of the editors of Egil Talk, the blog, and I was actually reading one of the comments that somebody put on the blog about a week ago. I only read the comment this morning, and it was a comment that had actually been posted to something which was published a few weeks ago, in fact. But it actually dealt precisely with this question of the relationship between Security Council action and the non-intervention principle. So let's remember that in the text of Article 2.7 of the UN Charter, and this is the provision of the UN Charter that provides for the non-intervention principle in relation to the UN, the text of it actually makes clear that that principle does not apply to action that's taken under Chapter 7. So there'd be no, you know, the non-intervention principle just doesn't apply once the UN once the Security Council is acting under Chapter 7. And then you save the most difficult till last. So in one sense, it's not very difficult, but in another one, it is difficult. Not difficult because my own view is that international law does not allow for unilateral humanitarian intervention, by which I mean humanitarian intervention by the individual states or collective states that is done without the authorization of the Security Council. So that's what I would say. Having said that, though, as I indicated towards the end of my talk, that we might start to think about ways in which maybe some kind of recommendation or approval by the General Assembly would actually provide a legal basis for taking action for humanitarian grounds. So going back to the Uniting for Peace resolution and thinking about whether or not we can say that there's subsequent practice that establishes the agreement of the parties. I'm not sure we have it yet, but I actually think it's possible to get there.
Okay, we are right on time. That was very, very sharp. Thank you so much, Dapo, for a fascinating talk and a great Q&A. I think you've given us enormous food for thought on sources and the use of force, the role of the ICJ and the Security Council. Thank you so much for doing this, for being with us at Ditela today. And we really hope that next time it will be in Buenos Aires. In the meantime, best of luck with your candidacy, and we'll keep in touch. Thank you.
Thank you so much. Thank you. It's a pleasure.
Bye. Thank you, everyone.
Bye-bye.